yet on the Supreme Court's website, but the few reporters that have been allowed in the court are at the court are reporting this news. So the law out of Texas is SB 8, which is a 6-week abortion ban. It's the most restrictive in the country, and we know that the other case out of Mississippi, that's going to be argued on the merits December 1st. By November 1st, the court is looking at, it appears, a few different issues. One, can the government even bring this kind of action against a state, or against, even in this case, even a judge or an entity like that? So that's one. There are reports that they will also, on the same day, hear the challenge the federal government's brought to the constitutionality of the law itself when it comes to abortion. But the reporting is also saying that this is on November 1st, so we're talking about a week. And within a week, they're going to handle hear at least many different issues. Now the court orders just got posted to the website.
Okay, so we'll take a look. You keep talking, I'll take a look at the court order.
Yes, what's interesting, I mean, it's a very short order.
Here it is. Yep, the petition for the writ of certiorari before the judgment is granted. So there's not been a judgment, but they're going to hear the case. The briefs to the party are limited to 13,000 words. So those are short. To be filed on Wednesday, October 27th. Reply briefs, if any, are limited to 6,000 words, are to be filed electronically before October 29th. Any amicus brief filed electronically on or before Wednesday, hang on, here something just came up, Wednesday, October 27th, we have to really turn that. Booklet format briefs prepared in compliance with Rule 33.1 shall be submitted as soon as possible. That's the printed version. The case is set for oral argument November 1st. There are a couple of things that can happen here. Number one, it's going to move very quickly, so we got to make sure we can get on record on that. Obviously, it's limited in what you can say. But there's two issues that they're going to address. They're going to address whether the federal government, whether the state government could be basically handled by the federal engagement in this case, and not as the Department of Justice entering the brief. And secondly, the constitutionality. But some are speculating that what this could mean is that the court could say, you know what, the Texas law doesn't go into effect because it empowered private citizens, but then they're saying, but that'll give the court the open door then to take action on overturning Roe versus Wade. You know what? It's all speculation. We have done expedited cases. I will tell you what this does mean, Jordan. You know that. This is going to move very, very quickly. 1 month later, Dobbs being argued at the Supreme Court on December 1st. Our case, our brief on the 8th Circuit Court of Appeals for the state of South Dakota, I think is due in 10 days. So you have the three biggest abortion cases either at the Supreme Court or the next highest court all within a month.
Yeah, so the entire month. So politically also this is going to have a huge impact because all these debates in Washington, D.C., they will try to refocus the issue. We've seen the refocus the issue. Court packing, court adjustment, whatever you want to call it, term limits on judges and justice of the Supreme Court. These are the issues that fuel all of that in Washington, D.C. So then it's going to be a month of the abortion battle in Washington, which is, again, they come up, we knew it was going to be big with the Dobbs case December 1st, but now it's going to be 30 days of a lot of focus on this issue.
Jordan, I think it's going to be the most monumental 6 weeks for the cause of life in my lifetime. I mean, literally, I think that's what the case is going to be. And look, I mean, as Jay goes through the mechanics of this, there's going to be a lot of nuance, and you might feel like you win a little here, you lose a little here. But at the end of the day, Jordan, after both of these cases are decided, if states have the ability to regulate pre-viability under a Roe and Casey standard, pre-22 to 24 weeks gestation, Jordan, that would be a monumental win, and state legislatures across the country could do what Texas and Mississippi have and take a look at their laws and see what they want to protect.
Let me tell you what we're going to have to do here, and I'm kind of giving the game plan on radio and TV here. We're going to need to file a brief, and I don't know, Dan, if we're going to have time to get members of Congress or not. I don't know. We got to file this thing. It has to be filed by October 27th, and it looks like limited in words too to 6,000 words. So it's going to be, it's going to be short briefs, you have to be concise, but we've got to get on record of this. I think what you said is right, Andy, and I'm going to Harry next. Andy, this is monumental. You got this, you got Dobbs, you have South Dakota. I mean, this is the Supreme Court is about to deal with the three most significant abortion cases in our lifetime.
That's true, Jay. We are at a crossroads. We are basically at a crossroads as strict and as overwhelming as Roe v. Wade in 1973.
Right.
That's where we are today.
No, I think that's right here.
Well, I think this is very, very important. And it's very important for a number of reasons, not the least of which is that Texas has created a very innovative law in which there is no state defendant that can be named by proponents of abortion. So the court could, and this is pure speculation on my part, say that the pro-abortion groups, Planned Parenthood and the like, they will have to wait until a citizen of Texas actually seeks to enforce this law. Then there would indeed be a Texas defendant. Or the court could say, this simply goes too far. But I think it's an interesting case study at the end of the day in federalism.
Yeah, so again, I just want to repeat for everybody, if you're just joining us, you're just catching the broadcast, what's happened here. This order just came out from the Supreme Court on the Texas abortion law. That law, remember, was a private right of action. It was not the state enforcing the law, but it was actually individuals who could bring a private right of action in civil court against someone who violated this, basically the 6-week abortion ban in Texas. That law has been able to exist, so it hasn't been stopped by any courts along the way. And the Supreme Court, even by this move, by saying, a week from Monday we're going to have an oral argument on this case, the briefing's got to be even before that. The key that I want you all to understand is that they're allowing these laws to stand while they're waiting through the merits of the case, the briefing of the case, the argument of the case, and ultimately their decision. And so, again, you cannot read into any of these moves. The emergency action to some might be concerning, but it's also, it's a huge, for them to move anything in a week is a big deal.
No, I've had these emergency stay cases before. This is beyond an emergency stay. This is a substantive determination. Now, look, the court's going to probably be, there's a whole lot of different ways they can go on this. constitutionally, but you got the setup of a 6-week period here that's going to be monumental. And I just sent out a thing to our team to get our group of lawyers together to get on this quickly, because you're going to have to file this on Wednesday. So we're going to have to be on top of this very, very quickly. But we're going to file. We have to file. This is the kind of situation where this is what the ACLJ does. And I think the federal government entering it the way they did was wrong. So there's a lot of constitutional issues here, and just a little bit of space to lay them out. So you're going to have to be, this is a brief that's going to have to be very, very precise as we move this forward. But rest assured, your support of the ACLJ allows it to happen. We're going to be on it this weekend.
That's right. So follow aclj.org. That's aclj.org for updates on this, for updates in the battle against the IRS. The new piece is up. A new piece up by Mike Pompeo earlier this week, Rick Riddell today. So a lot of resources available. You can also sign the petition to stop the blind abuse of the IRS. We've also got an email out today on our work involving the life issue, which is one of our core issues at the American Center for Law and Justice. And now these battles are coming right in a row, one after another, and both sides are going to utilize it. The question is, again, the American people getting the attention and focus on the right issue. So go to aclj.org. Stay with us as we unpack this information coming out of the Supreme Court on live. It's aclj.org. And we'll talk to you on the broadcast next week.
Have you been putting off life insurance for a while? With the long application process, medical exams, and blood tests, it's no wonder you put it off. It can seem so confusing, expensive, and time-consuming. But Ethos is a new way to buy life insurance. Ethos is built with you in mind. Instead of a medical exam, you only